Ms. Harris?
Mr. Chief Justice, and may it please the Court. Limits on party-coordinated expenditures unconstitutionally restrict core election speech. Intervening developments have demolished Colorado II's contrary holding. Indeed, even under closely drawn scrutiny, this Court's recent cases dictate invalidation for many reasons. First, these limits do not serve the only valid interest of preventing quid pro quo corruption or its appearance. Parties can't corrupt candidates, and no evidence suggests donors launder bribes by co-opting parties' coordinated spending with candidates. Second, there is a fatal mismatch between any anti-corruption interest and Congress's exception-riddled limits on party-coordinated expenditures, which would be a nonsensically convoluted means of thwarting donor corruption. And third, alternatives like FEC's disclosure regime and earmarking rules already check quid pro quos and are operating more effectively today. I welcome the Court's questions.
Ms. Harris, in your reply brief, you say that the FEC will continue to enforce its rules. But how do they do that when the government argues that the rules are unconstitutional?
Yeah, so we have not disclaimed enforcement, and it's the same way that the government has done so in cases such as Windsor and cases such as Chadha. The government and executive branch has traditionally distinguished between declining to defend the constitutionality of a statute and continuing to enforce it, particularly in situations like here, where enforcement is something that preserves judicial review. Now, you don't even have to agree with that proposition. You can cast doubt on government enforcement if you wish. The reason this case is easy on that score for jurisdictional purposes is that FECA also has a private enforcement mechanism. And it is abundantly clear that there is a very credible risk of enforcement through that private mechanism because many parties avail themselves of it. There's a rich sort of DC Circuit jurisprudence on how this happens. So again, for mootness, the other side would need to establish that there is no possible credible threat of enforcement either way. I really don't think they can do that. Now, again, I think the jurisdictional issues are a prelude to the merits. And on the merits, we just don't see anything left of Colorado II standing. That is why the government is here not defending Colorado II and not defending this particular law. And that is for multiple reasons. I think if you just look at the theory of undue influence upon which Colorado rested, that's probably the cleanest holding in this case. There is no way that you can look at Colorado II and say it rested on the theory that we've all been talking about now, which is preventing circumvention of quid pro quo corruption or its appearance. Colorado II is rife with references instead to a theory that there might be undue influence if donors decide to try to evade campaign finance restrictions so that they could concentrate on having large donors at the expense of attracting many donors. That is not a theory of quid pro quo corruption that this Court is allowed.
Counsel,